Now, as I just said in the previous video, as you have understood about the basic theory or the concept of equality, because there are many concepts that are directly used until and unless you understand that idea, what the content of the fundamental right says, you will precisely not be able to figure out. So please go through that lecture, just the previous one, in case you have not. Okay. So here now we technically start a discussion on the fundamental rights. The first set of heading is your right to equality, as you have seen this in the previous videos also. So fundamental rights part 3, two general articles 12 and 13 that we have already covered. From 14 onwards starts your right to equality. So in this video we'll just focus on this one right, because you will understand that there are so in-depth meaning associated to it. Okay, so therefore this is something that we are not going to just do in hurry, and I'll take separate videos on. Accordingly I'll divide all these articles, and jiske liye jitni zarurat padegi, accordingly I'll take all of these articles. Okay, and till here we have the equality rights. Let's read it first. What does it say? Firstly, the heading is equality before law, and then it tells you state shall. Now you know that what is the meaning of state here. They have already given you that whenever they are telling state, it includes what all things. So now it should not be a confusion. Okay. So state shall not deny to any person. Now please notice we have done the different categories also, that some will be given only to the citizens and some will be given to both the citizens and the non-citizens, like the foreigners. So when it is telling persons here, it means citizens plus foreigners. Okay, that is understood here. Then, what the state should not deny to any person for that matter? Equality before the law. So there is one concept of equality before law, or equal protection of laws within the territory of India. So even if they are foreigners, of course not enemy aliens, but just foreigners, so they will be given that treatment within the territory of India. So what are the two concepts? Equality before law and equal protection of law. What is the difference between them, and are they same, or what exactly is, how do we differentiate? So now let's try to understand only article 14, very important one. So article 14 says equality before law and equal protection of law. When it is telling person, as I have just given you the idea, within territory of India. Now when we say this idea of equality before law, please understand some 2-3 basic differences between these two concepts. Equality before law is of British origin and equal protection of law is of American origin. Firstly, you remember these 2 pointers. Secondly, it is a kind of a negative concept, equality before law, and equal protection of law is kind of positive concept. How? Now we'll try to understand. Now let's read this. It says equality before law. Matlab, before the law, in front of the law, everybody is equal. Okay, sounds simple, but not that simple. But yeah, let's just try to understand this. So if it is telling that before the law, everybody is equal, which also means that we are not giving any special privilege to any particular person or a group or something like that. So we are denying, or we are assuring that there is absence of any special privilege. Therefore, it is considered as a negative. It is not negative in the sense that this is wrong. Definitely not. Otherwise, why would had it been in the constitution? The idea is giving anything, which is absence of something, or which is restraining or constraining something, you get a negative connotation from that. This is the only thing. Okay? And positive would means that you're giving something. Here you are not giving something. Here you are giving something. So negative concept mein, what are you not giving? You are not giving any special privilege. Because if you will not give any special privilege, only then you will have equality before the law. Right? लॉ के सामने सबको इक्वल बनाना है, तो आप किसी को भी स्पेशल प्रिविलेज नहीं दोगे, तभी तो लॉ के सामने सब बराबर बनेंगे ना. So here it will be absence of any special privilege in favor of any person. Now when we say person, there is a very broader understanding of it. It is about the citizen, it is about the legal persons like any statutory body, company, corporation, etc. also. Then definitely foreigners and all of that. Okay? So firstly, you're not giving any special privilege. Secondly, you are making equal subjugation of all persons to ordinary law of the land administered by the courts. So law of the land जो सबके लिए applicable होगा, जो courts जिसको देख रहे होंगे, you are making every person equally subjugated to that, equal subjugation of everyone. So law of the land की जब भी बात होगी तो वो सबके लिए equally applicable होगा. आप special, again the same thing, no special privilege. And no person is above the law. The person is rich, the person is poor, the person is ordinary citizen, the person is having a higher post, etc, etc. But then you will say in the previous video we did talk about that we are ready to accept certain important privilege given to certain extraordinary people. वो exceptions में आते हैं. So that we'll just see. But otherwise it has to be no person above the law. ठीक है, that is equality before law. When you talk about equal protection of law, as I just said, this gives you roughly a positive idea. What is the positive idea? That you are treating. So what is it telling? That you are equally protecting the law. Equally protecting the law means if there is equal, or let's say not equal in a real sense, but let's say in a similar situation. So if there is similar situation, you will treat everyone accordingly, but you cannot treat somebody who is not in a similar situation as equal. Here what does that mean? The same thing. Let's say अगर हम physically challenged people की बात करते हैं, they are facing any kind of physical issues, so they are not equally placed with a person who is not having any such challenge. So in this case you cannot treat them equally. So here what you have to ensure that if you have to equally treat the people, they should be in a similar situation, they should be placed in a similar situation also. तो इसका broader connotation क्या है? That you have to ensure equality of treatment under equal circumstances, which I just said. Either it is about giving any privilege to anybody, or state is imposing, by the law, state is imposing any liability. कि punishment भी अगर दे रहे हो तो equal circumstances में if there are people, then you are giving equal punishment also, or you are giving any equal privilege, but the situation has to be similar, equal circumstances. दो unequal चीज़ों को आप तोल नहीं सकते. You cannot measure two unequal situations and people accordingly. Then similar application of the same laws. If the law is same, it should be similarly applied to all the persons, but again the condition is who are similarly situated, having the similar circumstances. And very important idea, that like should be treated alike without any discrimination. So it should be like as in everything looks similar. So if they are like each other, if they are in a similar situation to each other or a position to each other, then only you will treat them alike and there should not be any discrimination. ठीक है. अब सुप्रीम कोर्ट ने ये भी बोला दैट आर्टिकल 14, ये तो है ठीक है, कॉन्स्टिट्यूशन में बस ये दो टर्म्स दिए गए हैं. अब सुप्रीम कोर्ट ही तो उसको इन डिफरेंट केसेस विल इंटरप्रेट इट ना. इफ यू जस्ट सी द ओरिजिनल कॉन्स्टिट्यूशन, you just get this much of idea. So how does these terms get into you would say the explanation mode? Definitely by the judiciary. So हम अब समझते हैं कि सुप्रीम कोर्ट ने क्या बोला कि आर्टिकल 14 ये वाला जो है इक्वालिटी बिफोर लॉ एंड प्रोटेक्शन, इट विल नॉट अप्लाई वेयर इक्वल्स एंड अनइक्वल्स आर ट्रीटेड डिफरेंटली. सो इफ़ यू आर ट्रीटिंग इक्वल्स एंड अनइक्वल्स डिफरेंटली, वहाँ तो वो अलाउ ही नहीं होगा ना. वो तो दिस इज़ नॉट गोइंग टू बी एप्लीकेबल. इट हैज़ टू बी द सिमिलर सिचुएशन ऑफ ट्रीटमेंट. एंड देयरफॉर आर्टिकल 14 permits reasonable classification, because you will have that idea of differential treatment. If you remember, we have talked about it. To assure equality, you need differential treatment to certain groups and therefore certain reasonable classification. So if the state is making any classification of person, object, transaction, etc., that has to be reasonable and it should not be arbitrary, artificial or evasive. ठीक है. Arbitrary, random नहीं होना चाहिए. Artificial, there has to be some reason behind it. And evasive, like just you are skipping something, ऐसा नहीं होना चाहिए. So now your question should be that what are these classifications or the types of classifications that we may be talking about. Now let's say, for example, the best example that I could just think of right now is about the taxation system in India. You know that we have tax brackets. So different people who are getting different incomes, we have certain brackets or slabs. Bracket slabs mean certain levels कि इतने से इतने तक का इनकम है तो आप यहाँ प्लेस्ड हैं, फिर उसके ऊपर का है तो यहाँ, उसके ऊपर का है तो यहाँ, सिमिलरली. एंड डिफरेंट tax rates are like applicable 5-10 etc etc. We have now 2 taxation scheme. Older one also is prevalent and newer one also, and you can choose, the people who go for filing the income tax return, they have to choose either of them. But anyways, let's not get into the details of the taxation system. What we're trying to understand is that is a reasonable classification you are making, state is making. Because if somebody is earning, let's say 5 lakhs annually and somebody is earning 50 lakhs annually, how can you treat them equally? They are not in a similar situation. So you need different treatment for them, and therefore it is allowed that you are giving reasonable classification. Because in that case, somebody cannot come to you and say that Article 14 violate हो रहा है कि हमें तो equal treatment ही नहीं मिल रहा है, because आप equal situation में हो ही नहीं, so आपको equal treatment नहीं मिलेगा. ठीक है? I hope you are getting this idea. Now, when we talk about this equality before law, this has actually come from a very major idea of rule of law. उसमें 3 components होते हैं, जिसमें से एक होता है equality before law. So उसको भी हम एक बार देखेंगे. And Supreme Court has also said that Article 14 is a basic feature. This rule of law, the whole idea is your basic feature, and therefore you need to be very very particular about it also. अब क्या बात है, ये रूल ऑफ लॉ का कॉन्सेप्ट दिया किसने? ये कॉन्सेप्ट दिया एक ब्रिटिश जूरिस्ट ने, जिनका नाम था A.V. डाइसी. अकॉर्डिंग टू A.V. डाइसी, इन हिज कॉन्सेप्ट ऑफ रूल ऑफ लॉ, कि रूल किसका चलना चाहिए? लॉ का चलना चाहिए. देयर वर 3 डायमेंशंस दैट नीड्स टू बी कवर्ड, 2 of which is applicable to Indian system, 1 is not applicable to Indian system, and we'll see what is that. 3 elements, the aspects of rule of law of A.V. Dicey says. 1 is that there should be absence of arbitrary power and no one can be punished except for a breach of law. मतलब the state cannot showcase any arbitrary, any random power and punish any person even if the person is not guilty. So a person will only be punished if there is a breach of law. So we understand that yes, this is what we apply in India. Okay. Another element says equality before the law, and the detailed explanation of equality before law, that you're not giving any specific right to any person, etc etc. So that is also applicable in the system. Third is, because वो ब्रिटेन की बात हो रही है ना, तो वहाँ पे ये बात उन्होंने क्या बोला, that there should be primacy of rights of individual का right सबसे supreme होना चाहिए. Why did they put this argument? Because according to them, Constitution is not the source of the right of people, but it is a result of the right of people. According to them, that the people have got their rights and then they have made a constitution. So constitution is basically the result of the right of people. Constitution is not giving right to the people, according to them. And therefore, this is not applicable in case of India. Why? Because in our case, the constitution is the source of individual right. तभी तो आप ये fundamental right का chapter पढ़ रहे हो ना, part 3. So you have to remember these two being applicable in the Indian system. This is not applicable in the Indian system. ठीक है? चलिए. Next हम बात करते हैं, as I just said, that there are certain exceptions also that you have to remember. So what are the exceptions to equality? There are certain constitutional exceptions which are very clearly given in the constitution, and some other exceptions to this rule of equality before law, that कि we are not giving special privilege. उसमें कुछ exceptions हैं जो कि constitution ने ही खुद बताए हैं. For example, the first one, as you can see, Article 361 बात करता है कुछ immunities की, immunities as in कुछ extra protection की, to the president and the governor. What kind of immunities? And immunity है मतलब हम exception दे रहे हैं ना, नहीं तो फिर तो special treatment एक जैसा हो जाता. तो special treatment तो दे रहे हैं, but कुछ exceptions. So what are those immunities that the president and the governor gets? Firstly, that they are not answerable to any court for exercise and performance of power and duty of the office. So president and governor, when they are in office and they are having the powers and they are performing those powers or they are performing those duties, so in that manner they will not be answerable to any court कि आप ये काम ऐसे क्यों कर रहे हो. Secondly, no criminal proceedings will be done against them during their term of office in any court. जब तक वो ऑफिस में है, no criminal proceedings against them. ठीक है. Third, there will be no, because no criminal proceeding, so there will be no process for arrest या imprisonment also. कोई भी कोर्ट ऐसा कोई ऑर्डर इशू नहीं करेगा जब तक वो लोग ऑफिस में हैं, ड्यूरिंग देयर टर्म ऑफ ऑफिस. ये तो क्रिमिनल प्रोसीडिंग की बात हो गई. व्हाट अबाउट द सिविल प्रोसीडिंग? सो देयर विल बी नो सिविल प्रोसीडिंग्स ऑल्सो अगेंस्ट देम ड्यूरिंग द टर्म ऑफ ऑफिस इन एनी कोर्ट. कोई भी कोर्ट कोई ऐसी प्रोसीडिंग नहीं चलाएगा इन रिस्पेक्ट ऑफ एनी एक्ट डन बाय हिम in his personal capacity. Even personally, if the president or the governor has done something and you otherwise find कि नहीं ये तो civil issues को deal करता है and civil proceedings होनी चाहिए, but it cannot be done in the case of president or governor. Now whether the person has entered the office उसके पहले या उसके बाद, in both the cases, ठीक है, until expiration of 2 months after notice delivered to him. मतलब 2 महीने तक के लिए आप वो कोई ऐसी प्रोसीडिंग नहीं चलाओगे. 2 महीने का एडवांस नोटिस देके आप प्रोसीडिंग चला सकते हो. क्रिमिनल के केस में तो चलाना ही नहीं है टिल द टर्म ऑफ ऑफिस कंटिन्यूस, बट इन सिविल केस में 2 महीने के नोटिस पर आप कर सकते हो. ठीक है. बेसिकली द आइडिया इज सर्टेन इम्यूनिटीज एंड द स्पेशल प्रिविलेजेस विच आर गिवन इन द कॉन्स्टिट्यूशन इटसेल्फ. व्हाट आर द अदर एक्सेप्शंस? अनदर आर्टिकल सेज no person liable to any civil criminal proceeding in any court in respect of publication in a newspaper, radio, TV of a true report of any proceeding of either house or state legislature. Let me simplify this. You might get confused, but I'll simplify this for you. So you know this, that parliament में जो भी sessions चल रहे होते हैं, जो उनके proceedings होते हैं, या विधानसभा के जो अपने proceedings होते हैं, that is telecasted live. ठीक है, that you know. So if any person is reporting in anything in a newspaper about the proceedings of the legislature, state या central जो भी, so if they are publishing anything in the newspaper, radio, TV, but and that is a true report, of course not a fake report, so that is very clearly mentioned. If the true report of the proceedings, because it is all about democracy and you need to be transparent in that. ठीक है. So if somebody is reporting very truly about whatever is happening in the parliament, then the person will not be liable to any civil or criminal proceedings in any court. So basically to the journalist and the media persons, you are giving that exceptions until and unless this is true reporting of the events or the proceedings. Then another article is about that no member of parliament will be liable to any proceeding in any court in respect of anything said or any vote given by him in parliament or any parliamentary committee. So parliament में या किसी भी parliamentary committee में, if a member of parliament has said anything or given any vote, उसको बोल करके आप उनके अगेंस्ट में कोई proceeding नहीं लगा सकते. वो उनका अधिकार है to participate in that and the person is participating in that. ठीक है. The same, because here it is for the member of parliament, the same logic applies for the member of assembly or council also. Okay, now you know the basic idea of legislature and executive, so I hope you will understand all of this. If you have not done the previous videos of the basic concepts, you would need to revisit them, because I cannot explain every time what is this MP and what is ML and MSc. These are very basic concepts. You should know about it. Then laws made by state to implement DPSPs. You know about 39BC. इसको लेके क्या क्या फंडामेंटल राइट्स के साथ इश्यूज रहते हैं, हमने पहला कर ही लिया था. ठीक है. सो इफ़ द स्टेट, बिकॉज ये तो 31C है, हमने करे हुए एक्सेप्शंस टू फंडामेंटल राइट. 31A, 31B, 31C, रिमेंबर एक्सेप्शंस टू फंडामेंटल राइट्स, बस उसी में है. सो सेम थिंग यू हैव ऑलरेडी डन and you cannot challenge such rights on the ground that they are violating Article 14. Then you also give certain exceptions to, let's say, certain foreign sovereigns, some rulers, some ambassador, diplomats who are enjoying immunity from the criminal and civil proceedings in India. Also the United Nations organization and the agencies, इनको भी diplomatic immunity मिलती है इंडिया में. ठीक है. So these are the exceptions to equality in this case. In the next class, we'll deal with the next two articles, 15 and 16. But I hope the two concepts that are given in Article 14 about equality before law and equal protection law are clear to you.